Subcommittee on the Administrative State Regulatory Reform and Antitrust. The chair now recognizes himself for an opening statement. In some ways, the importance of today's hearing goes back to the founding era. Even before America declared its independence, John Adams emphasized that a republic is a government of laws, not of men. This hearing is about who makes the laws in our country. It's also about how Congress should reclaim its legislative power from the administrative state. This is an important discussion. By way of background, the U.S. Constitution separates the powers of government between the states and the federal government. It further separates the powers among the three branches of the federal government. Importantly, Article 1 of the U.S. Constitution vests the federal legislative power in Congress. In other words, the words of Chief Justice John Marshall, powers are separated with the intent that the legislature makes the law. But in the modern day, we have seen a troubling consolidation of powers in the executive branch. That is, in part, because of how many regulations, binding rules that affect the American people are coming from the executive branch. Indeed, in recent years, the administrative state has issued regulations carrying the force of law more than 20 times as frequently as America's elected representatives have passed laws through the process the Constitution requires. When Chairman Jordan invited me to chair this subcommittee, I asked him what the topics were, what would be our jurisdiction. And he said that administrative law would be our jurisdiction. And I said, well, you've just given us jurisdiction over about 95% of the federal government, and I'd be happy to chair that committee. What this means that so much of the law is administrative law, unelected bureaucrats and the branch tasked with executing the laws are instead making many of those laws that bind the American people. The modern administrative state's violation of these fundamental principles is significant. In our country, lawmakers should be politically accountable to the electorate. As Professor Philip Hamburger wrote in his book, The Administrative Threat, quote, "These are core civil liberty issues. Binding agency rules deny Americans their right under Article 1 to be subject to only federal legislation as enacted by an elected Congress, and such rules thereby dilute the constitutional right to vote. But today, Americans must routinely follow rules that come from a source other than Congress. In recent years, federal agencies have more and more frequently imposed their will on the American people. To name just a few examples, OSHA's vaccine mandate, the national eviction moratorium, the FTC's proposed non-compete rule, and ATF's recent rule on stabilizing pistol braces, not to mention waters of the United States, which incidentally is like a ping pong match. Every time we get another administration, whether we went from the Bush administration to the Obama administration, we got a new waters of the U.S. law, a new interpretation of the Clean Water Act. And then when we went from Obama to Trump, we got a new interpretation of the Clean Water Act. And now we've gone again to Biden's rules. Each of these examples shows the administrative state, not Congress, attempting to or actually imposing binding rules on the American people. Consider the ATF's pistol brace rule. It requires gun owners who use stabilizing braces, not bump stocks, Mr. Ranking Member, to register their braced pistols, modify their weapons, or risk potential felony charges. In the words of James Madison, the accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of tyranny. That quotation by James Madison implicates an administrative state that makes law. Today's hearing is about exploring the need for Congress to reclaim its legislative authority and to discuss potential legislative responses. Some legislation, like the REINS Act and the Separation of Powers Restoration Act, are steps in the right direction. Ultimately, Congress needs to reestablish itself, not government agencies, as the main driver of federal policy. I'll end with this final point. Although some conflate this hearing's focus with deregulatory efforts, that need not be the case. We're not arguing that there don't need to be any regulations. Put simply, we can and should have a discussion today about where law should come from. And as set forth by our Constitution, binding rules should come from politically accountable elected representatives, not from the administrative state. Reasonable minds may differ about certain policies, but we in this body should all be on the same page about who should be making our laws, and that is Congress. Before I recognize the ranking member, I want to thank him for his service in Congress and tell him that we're going to miss him. I hear that he's leaving this session early, and I hope it's not because I am the chairman of this committee. And now I recognize the gentleman from Rhode Island, Mr. Cicilline, for his opening statement.
Thank you, Mr. Chairman, and I congratulate you on chairing this committee and for our first hearing, and can assure you that your ascending to this chairmanship did not contribute to my decision to leave early. Mr. Chairman, it's just over a month now that the Suffolk Southern train derailed in East Palestine, Ohio, setting off a cascade of events that have put countless lives at risk. Crews are still cleaning up the highly toxic chemicals that were released into the water, ground, and air. We will not know the full effects of this environmental and safety disaster for decades. This subcommittee is charged with overseeing regulatory reform, which is clearly much needed. And yet today, instead of using our first hearing to discuss what and how we must ensure that the government is acting to not only help those in need right now, but also to implement new safety and environmental regulations that would prevent a disaster like this from ever happening again, we're talking about, and I quote, reclaiming Congress's legislative power. I frankly didn't know that this is a power that had been lost. And at the center of today's hearing is, of course, the regulations from the Executive in Need of Scrutiny Act of 2023, or the REINS Act, which would not, in fact, make rulemaking more efficient or responsive to public concerns, but instead would hinder the most basic functions of our government to keep people safe. By requiring that both the House and Senate pass and the President sign a joint resolution of approval before any major rule issued by an agency can take effect, we are effectively negating the authority we have already given these agencies. Let me make it plain. Congress already has the power to oversee agency rulemaking, and agencies can only exercise authority that we grant them. What the REINS Act would do, in short, is prevent agencies from keeping dangerous products off the shelves and toxic chemicals from polluting our land, air, and water. This is nothing more than a congressional power grab that will lead to even more deregulation that puts people at risk and will pave the way for reckless and powerful corporations to put their profits ahead of the health and well-being of the American people. The REINS Act would prevent the Consumer Product Safety Commission from updating safety standards for infant walkers like they did in late 2022, responding to alarming news that these products had become a leading cause of death and injury for small children. The REINS Act would prevent rules from the Food and Drug Administration, like their August 2020 rule to more quickly identify and remove potentially contaminated food from the market, resulting in fewer deaths and illnesses. And finally, rules like the FDA's hearing aid regulation that will lower costs for millions of Americans and allow people to get hearing aids over the counter would be blocked under the REINS Act. Deregulation led to last month's derailment in East Palestine and Norfolk Southern's recent derailment in Springfield, Ohio. Further deregulation will lead to even more tragedies in the future. For years, at the behest of companies and special interests, the Federal Railroad Administration has engaged in deregulatory efforts despite workers' calls for necessary, stronger safety measures. We cannot place companies' greed over public and worker safety and the cleanliness of our air, water, and land. Railroad workers have a saying that their safety regulations are written in blood, because it is only after disasters, up to and including the loss of life, that pro-safety changes are made. This is absolutely unacceptable. Agencies are charged by the authority of Congress grants to enforce our laws. They do that in part by issuing those rules. And to that end, I hope my colleagues on both sides of the aisle will join me in supporting legislation that would make industry and our government more accountable by ensuring that all agency-issued rules are based on rigorous studies and free from bias, like the Stop Corporate Capture Act introduced by Representative Jayapal. At a time when residents across 3 states are grappling with the highly toxic fallout of a culture of deregulation and lax safety standards of the Trump administration, we need to be focusing on how to make rulemaking more effective and efficient, not gunking up the wheels. And I thank you, Mr. Chairman, and with that, I yield back.
Thank you, Mr. Cicilline. I now recognize the ranking member of the full committee for his opening statement, if he has one.
Thank you, Mr. Chairman. Mr. Chairman, at a time when the nation is reeling from multiple train derailments in Ohio alone, as well as increasingly harsh storms due to climate change, and an outbreak of avian flu that has led to the deaths of tens of millions of chickens in our food supply, and experts tell us could conceivably jump into other species, including humans, and could conceivably cause another pandemic, I find it telling that we are using the first meeting of this subcommittee not to discuss how we can better serve the needs of all Americans, but rather how we can remove public health and safety safeguards for the sake of higher company profits. And how do Republicans plan to advance their extreme agenda of protecting profits over people? By trotting out the same old, tired anti-health and safety legislation that they have tried year after year whenever they control the House. We are only 3 months into the new majority, and I guess they are already out of fresh ideas. One of the bills we are examining today, the regulations from the Executive in Need of Scrutiny Act of 2023, or the REINS Act, has been considered in every Congress in which Republicans have held the majority since 2012. The REINS Act would grind the gears of rulemaking to a halt by requiring all major rules to be affirmatively approved by both chambers of Commerce. A regulation would be blocked from being implemented if even one House declines to pass an approval resolution. The goal of this legislation, quite simply, is to stop the regulatory process in its tracks, regardless of its impact on public health and safety. The bill purports to give Congress control of the rulemaking process, but Congress already has this power and exercises it in a number of ways. First, Congress can delegate authority to agencies with specificity, thus limiting the scope of the agency's authority. Second, it can impose restrictions on rulemaking through appropriations. Third, it can influence rulemaking through oversight activities. And if all these measures are insufficient, we also have the blunt tool of the Congressional Review Act, which allows Congress not only to overturn a rule, but also to bar the agency from ever passing a substantially similar rule. The REINS Act is not only redundant, but it also creates insurmountable procedural hurdles that would stall the approval of rules of major impact, rules that would be highly beneficial to the public's health and safety. It's important to remember why we have regulations in the first place. Congress sets broad policies, but we delegate authority to executive agencies because we do not have the expertise to craft technical regulations ourselves. Who here knows how many parts per billion of arsenic should be allowed in our drinking water? Is 10 the proper amount? Should it be 5 or 15? None of us here knows the answer, but the dedicated professionals at our federal agencies, many of whom have decades of experience and vast technical expertise, undertake a careful process to protect our health and safety. This process includes numerous procedural safeguards, including public notice and comment. Regulations ensure that our air is safe to breathe, our water is safe to drink, our food is safe to eat, and the life-saving medications we depend on are safe and effective. It means that the cars we drive and the planes we fly have proper safety mechanisms, and that banks and credit card companies cannot take advantage of unsophisticated borrowers. And when we do not properly regulate, sometimes it means that trains carrying dangerous chemicals can derail in our communities, putting thousands of people at risk. I feel much better about leaving regulatory decisions to the careful study of agency experts rather than to members of Congress who want to substitute their judgment subject to the whims of politics. Republicans also want to eliminate the Chevron doctrine, which calls for courts to give deference to an agency's reasonable interpretation of its statutory authority. So if it's not members of Congress regulating our health and safety, I guess it will be federal judges. Republicans have spent decades waging an all-out assault on the regulatory process, trying to add hurdle after hurdle on the ability of agencies to issue regulations that protect public health and safety. Regulations whose benefits consistently outweigh their costs, often by many multiples. If we want to improve the regulatory process, we would consider legislation such as the Stop Corporate Capture Act, which would bring more transparency and accountability to the rulemaking process. But instead, the subcommittee has chosen to make their first order of business the dismantling and destruction of the regulatory process, regardless of the impact on public health and safety. This gives us a good idea of the priorities we should expect to see out of this new extreme majority. I hope they will reconsider this dangerous agenda, and I yield back the balance of my time.
Thank you, Ranking Member Nadler. Without objection, all other opening statements will be included in the record. We will now introduce today's witnesses. Allison Ho is a partner and a co-chair of the Appellate and Constitutional Law Practice Group at Gibson, Dunn, and Crutcher. She has argued cases before the Supreme Court, state Supreme Courts, and various state and federal appellate courts. She previously served as special assistant to President George W. Bush, counselor to Attorney General John Ashcroft, and she clerked for Justice Sandra Day O'Connor. Jonathan Wolfson is the Chief Legal Officer and Policy Director at the Cicero Institute. His research at Cicero focuses on healthcare, regulatory reform, and employment policies. He previously led the policy office at the U.S. Department of Labor. Ryan Klechner is the co-founder of Gun University, LLC, and a former Army Ranger. He is an attorney and previously served as Vice President of Compliance at the Remington Outdoor Company and as a manager of government relations at the National Shooting Sports Foundation. Emily Hammond is the Vice Provost for Faculty Affairs and the Glenn Earl Weston Research Professor at the George Washington University Law School. Professor Hammond's research focuses on energy law, environmental law, and administrative law. We welcome our witnesses and thank them for appearing today. We will begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? The record will reflect that the witnesses have answered in the affirmative. Thank you, and please be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. The microphone in front of you has a clock and a series of lights. When the light turns yellow, try to begin to conclude your remarks. When the light turns red, your time has expired. Ms. Ho, you have the distinguished honor of going first.
Thank you, Chairman Massey, Ranking Member Cicilline. Thank you for inviting me here today to testify about reining in the administrative state. I'm heartened to see this issue being debated in Congress. Our system of checks and balances can only work when Congress is active in its engagement with the other branches, including the executive branch. And that's particularly important when we're talking about the modern administrative state, where the executive branch regularly runs the risk of encroaching on the authority of the legislative branch. So regardless of what actions this Congress chooses to take in response to the rise of the administrative state, I think this hearing alone serves an important function in Congress fulfilling its responsibilities under the Constitution. In my remarks today, I want to discuss one specific issue that has coincided with and likely accelerated the rise of the administrative state, doctrines that force courts to defer to administrative agencies. The most well-known of these doctrines is Chevron deference, which originates from a 1984 Supreme Court decision, Chevron USA versus Natural Resources Defense Council. And that case holds that when a court is reviewing an agency's interpretation of a statute that it administers, the court should defer to the agency's interpretation if the statute is ambiguous and the agency's interpretation is reasonable. There are other types of judicial deference as well. For example, our deference holds that courts should give controlling weight to an agency's interpretation of its own regulation, unless the interpretation is plainly erroneous or inconsistent with the regulation. There are several significant flaws with judicial deference to agency interpretations, and I'd like to highlight just a few of them. First, it flies in the face of the bedrock principle underlying the rule of law. A law means what it says. A statute or a regulation has a correct interpretation, and it is that correct interpretation which should govern our actions. Deference to an agency's interpretation turns that fundamental principle on its head. Courts no longer care whether the agency has the correct interpretation, just whether the interpretation is reasonable. And suddenly this reasonable interpretation, which may or may not be correct, becomes the law. To enforce an agency's interpretation of the law, even though it is not the best interpretation, is inconsistent with the judicial branch's constitutional duty to say what the law is, contrary to Congress's directive in the Administrative Procedure Act, and harmful to confidence in our legal system. Second, deference doctrines have become a tool for agencies to expand their power and influence, often at the expense of individual rights and freedoms. One of the biggest problems with deference is that it allows agencies to effectively write their own laws. Because courts are required to defer to an agency's interpretation of a statute if it's reasonable, agencies have an incredible amount of discretion to interpret laws in a way that gives them more power and authority. This can result in regulations that are far more burdensome and restrictive than anything Congress intended when it passed the underlying law. And third, these deference doctrines undermine very fundamentally the separation of powers that is so critical to our system of government. When agencies are given broad authority to essentially write the laws, write regulations that have the force of law, they are stepping into the role that Congress has, not the executive. Moreover, even though agencies are technically within the executive branch, the rise of the civil service and the vast expansion of the federal bureaucracy has effectively made them a fourth branch of government with the power to make laws and enforce them with little effective political oversight. Elected officials are supposed to be held accountable to the people who elected them, but the administrative state is often staffed by unelected bureaucrats who are difficult to hold accountable, even by the executive. This can make it hard for the public to have a say in the laws and the regulations that affect their lives. The more you believe in democracy, the more you should be concerned about the rise of the administrative state. So what can be done? There are many solutions, but part of the growth of the administrative state comes from congressional neglect. When Congress passes laws that are open-ended, when Congress doesn't react to civil agencies that are acting outside the bounds of their authority, all of that empowers agencies to continue expanding their influence. So to end where I began, I'm grateful for the committee's invitation to testify today. I hope I can answer any questions you have and help in any way I can in your efforts to rein in the administrative state. Thank you.
Thank you, Ms. Ho. Mr. Wolfson, you may begin.
Chairman Massey, Ranking Member Cicilline, and members of the subcommittee, good morning and thank you for having me today. It's an honor to testify on Congress's role in creating law and oversight when executive branch agencies start to write laws instead of simply working to enforce the law that's already written. My name is Jonathan Wolfson, and I'm the Chief Legal Officer and Policy Director at the Cicero Institute, which is a nonprofit think tank focused on identifying, developing, and advancing entrepreneurial solutions to society's toughest public policy problems. Previously, I had the honor of serving as the head of the Office of the Assistant Secretary for Policy at the U.S. Department of Labor, as well as the Regulatory Reform Officer at that department. Today's hearing centers on ways that Congress can bring additional accountability to federal rulemaking, whether by limiting the power of the executive branch to act absent congressional authorization or requiring legislative approval of regulations. Today, I will focus on 4 key points. First, the legislature should create laws, and the executive branch should encourage compliance and enforce those laws. Secondly, the legislative branch is more accountable than the administrative state. Third, agencies have expertise in regulatory process, not necessarily on making legislative decisions. And fourth, the REINS Act appears to be a valuable step toward restoring Congress's and agencies' appropriate roles. Before we dive in further, I'd like to clarify that while colloquially, regulation often means government restrictions, regulations are actually agency rules that purport to effectuate statutes. This is important because too often discussions of deregulation devolve into caricatures where proponents of deregulation are asked to defend whether they care about clean air, safe food, or fair banking practices. Congress can pass laws to protect air, food, or finances through statute without subsequent agency-driven lawmaking. So let's talk about why agencies are not supposed to make new laws. Basic Schoolhouse Rock civics lessons teach us that Congress makes laws and the president executes and enforces those laws. But members of this subcommittee know that that isn't really the reality. Unfortunately, the executive branch and independent federal agencies regularly make new laws and fill intentional or unintentional gaps left by Congress. and at times regulatory agencies even act to make new laws without any congressional authority at all. Now, Congress does bear some responsibility for this phenomenon. New laws are often vague. Sometimes this is out of neglect, sometimes it's out of convenience for the legislature, and sometimes it's out of apparent necessity. But often this leaves vague and big questions for the regulated community. But regardless of the cause, I would argue that this is not the ideal that we should be aiming toward. And as Ms. Ho just mentioned, this is not the ideal that the Constitution sets up for us. Secondly, Congress is accountable and agencies are not. Another key reason that agencies ought not legislate is that voters may hold legislators accountable for their action. Accountability is especially important where there are trade-offs between different constituents and competing interests. When a secretary supports a particular policy, the agency's staff do as well, that policy is likely to prevail. And traditional deference principles mean reasonable regulations stand, even in the face of strong objection. Given the substantial burden and the limited ability of Congress to hold the agencies accountable, Congress ought to write the laws. Third, unique agency expertise often lies in regulatory process. Some proponents of the administrative state contend that Congress lacks expertise on a range of issues that face our nations, and agencies have the depth of knowledge and experience necessary to write the laws. They argue that Congress could codify public sentiment and leave the regulatory details to the agency experts. While regulators do bring specialized knowledge and years of experience in government to the table, it does not follow that this experience makes them better at making the rules than a member of Congress would be if given the opportunity. Even assuming that the typical federal official writing regulations is a neutral, unbiased subject matter expert who leaves his or her own preferences aside, do they possess the right kind of expertise? Unfortunately, many agency staff have narrow expertise, often in creating and enforcing regulations, rather than on important trade-offs that occur in the real world. And even when they have field-level expertise, their relative comparative advantage compared to academic or industry is knowledge and experience in how the government works, how to get something published in the Federal Register. So they revert to regulation, even if regulation is not the best path forward, because regulators regulate. This knowledge of the rules also helps them impose new regulations via guidance, which doesn't have to go through all the Administrative Procedure Act hurdles. To limit this overreach, I was honored to sign the Department of Labor's regulatory openness through good guidance rulemaking. Fourth, Congress can use the REINS Act to rein in regulatory excess. The REINS Act is a good proposal to restrict legislative activity by agencies and restore the proper relationship between the legislative and executive branches. The REINS Act is the next in a series of laws to limit regulatory autonomy and require particular regulatory processes to ensure the constitutionally required balance of power. Thank you again for the opportunity to testify and share my perspective. I look forward to answering any questions you all may have.
Thank you, Mr. Wolfson. Mr. Klechner, you may go now.
Good morning, Chairman Massey, Ranking Member Cicilline, and members of the subcommittee. I am Ryan Klechner. I'm a former special operations sniper, and I'm a firearms attorney that specializes in federal firearms law and ATF compliance, among many other projects in the firearms industry. I am concerned with federal administrative agency overreach with respect to rulemaking. I believe that power in the government should be limited, and it should only be in the hands of those accountable to the people. And decisions and debates on matters in legislation should be open and transparent to the public. Allowing non-elected and non-representative government bureaucrats and federal agencies to exercise power that should be limited to Congress, and to do so behind closed doors without accountability nor transparency, is destructive to America, its citizens, and Congress. I implore you to not let these federal agencies under the executive branch continue to steal power that has been entrusted to you by us. A recent example of agency overreach where laws are being changed by unelected bureaucrats with decisions being made behind these closed doors is ATF's latest rule 2021R-08F. It's factoring criteria for firearms with attached stabilizing braces. It was published in the Federal Register on January 31st of this year. This latest rule that the ATF has made, it redefines laws that have been passed by Congress, and it criminalizes the possession of firearms with certain accessories that the ATF itself had previously specifically approved. This rule by fiat effectively gives the ATF the power to determine who is a felon by the stroke of a bureaucrat's pen. This is not an appropriate enforcement of law. It is tyranny. It's unfair for the ATF to expect the average citizen to not only be aware of these changes especially since the ATF itself has waffled back and forth over the years on pistol braces alone. But expects citizens to make these determinations about these objects themselves without clear direction about what the ATF considers to be legal. However, even with clear instructions, these changes to legal definitions within the law are not appropriate for the ATF to make. If Congress doesn't rein in federal agencies, and these agencies are permitted to continue to change laws and provide this conflicting guidance to citizens, I believe that chaos ensues. Thank you for the opportunity to speak here today, and I'm willing to answer any questions you may have.
Thank you, Mr. Klechner. Professor Hammond, you may begin.
Thank you, Chairman Massey, Ranking Member Cicilline, and distinguished members of the subcommittee for the opportunity to testify today. I'm a professor of law at the George Washington University Law School, where I do indeed specialize in administrative, energy, and environmental law. I have previously served in federal agencies, both as legal counsel and in my previous career as an engineer, where I co-authored several scientific publications. I am deeply concerned about the REINS Act. It's impractical. It's harmful to the people of this country. It eviscerates two cores of government legitimacy: participation and reasonableness, and it is likely unconstitutional. Congress has long recognized that among the branches of government, agencies within the executive branch are best positioned to leverage specialized expertise to tackle the most challenging issues that we face as a society. Whether protecting the functioning of our markets, keeping workers safe, or protecting the air we breathe, these challenges are incredibly complex and difficult to address solely in the legislative arena. So, in its wisdom, Congress establishes the statutory basis for action, but tasks the executive branch with the duty to bring that legislative vision to life. And Congress has put a number of guardrails in place. For rulemaking, these include the participation, deliberation, and reason-giving requirements that stem from the Administrative Procedure Act. Notably, these features of rulemaking are fundamental to democratic decision-making. They guard against arbitrariness, and they promote oversight through transparency. In particular, that reason-giving requirement ensures that Congress and the public can both understand the basis for the decision and see whether the agency has maintained fidelity to statute. Now, there is always room for improvement in agency decision-making, and Representative Jayapal's Stop Corporate Capture Act, for example, offers several upgrades. These are aimed at empowering the public, ending corporate manipulation, attending to social equity, and minimizing the dysfunction that OIRA review can engender. By contrast, the REINS Act would replace scientific-informed, participatory government decision-making with an utterly impractical system. Congress is neither designed nor staffed to deeply evaluate every single agency's major rules, especially within such short timeframes. And the suggestion that the REINS Act is meant to promote legislative transparency is baffling. It permits only 1 or 2 hours of debate on the joint resolutions, and otherwise sets such tight timeframes that it is difficult to understand how legislators could give careful review to each regulation. This scenario promotes opacity and heightens the risk that votes will be based on naked political preferences that would not be permissible in the agencies themselves. Right now, America needs more protections, not fewer. We know from the East Palestine disaster what an anti-regulatory culture can do, and we have seen these lessons across our history. We know as well that weak regulatory protections mean fewer people make it home to their families after work. More people die too soon, and we hasten and intensify climate disasters. This is not idle speculation. It's backed up by the cost-benefit analyses that the REINS Act asks for, but that are already available for review by Congress and the public. Finally, the REINS Act is concerning because it blurs separation of powers beyond what the Constitution can bear. On one hand, if the joint resolution process is a legislative act, it must meet constitutional requirements for doing so. On the alternative, it would violate separation of powers for Congress to exercise the executive function of finalizing regulations. To conclude, the unconstitutional REINS Act would fail to achieve what it promises and would instead harm our economy, our safety, our health, and our environment. Thank you again for the opportunity to testify today, and I look forward to your questions.
Thank you, Professor Hammond. We'll now proceed under the 5-minute rule with questions. And I recognize the gentleman from California, the chairman of the IP subcommittee, Mr. Issa, for 5 minutes.
Thank you, Mr. Chairman. You know, it's always interesting to be told something is unconstitutional in this body by a professor who just doesn't like how Congress might rule. So I'm going to start with Mr. Klechner, since you fought to defend our country and her right to be wrong. Let me ask you a question. Do you think for a moment that a body that regulates one way and then regulates another way is consistently meeting the congressional mandate that they interpret but not make laws?
Of course, it would depend on the situation, but the way it's happening now, no.
Right. In your case, they fully executed, knowing what the devices did, regulations and categories, and now they're changing them based on a political, oh, these are too dangerous, these are this, these are that. Whatever their reason is, they're making a political decision to make a change that is not supported by a change in the hardware or the change in the statute. Is that correct?
I believe so. I do not think this is a regulation that is promulgating current law. They are specifically in the ruling calling out what the current law is and then saying we are redefining that to be this instead. They're actually changing the language of the law and the definitions.
Mr. Wolfson, you looked a little uneasy as the last witness spoke. The unconstitutionalist claim that we just heard, is it correct, and I'll ask both the other witnesses, is it correct that we could strip every single statute by a rule, by simply the House and the Senate voting to do so, and eliminate all statutes since the beginning of time and start over if we chose to, and that would be constitutional?
My understanding of the Constitution is that yes, if Congress passed a law to strip all current statutes, that they would be allowed to do that.
So unless it is within the 27 amendments and the original Constitution, which we cannot strip by congressional fiat, everything else by a 2/3 majority over the objection of a president can be eliminated to zero. Is that correct?
That's my understanding.
Okay, so any failure in the REINS Act to meet some sort of a constitutional test as written would simply be that we probably didn't write the REINS Act quite specific enough to assert the powers that Congress clearly has. Is that correct?
I would assume that would be the argument, would be that the language of the REINS Act as currently drafted may have some sort of constitutional defect. But the concept of the legislature being able to say, we're going to create a rule that says all the regulations have to come back to Congress, considering Congress theoretically gave the agency the authorization to write them.
Right, and so now in the case of the Federal Trade Commission, which you opined on, clearly they are now asserting areas that they never asserted for their first decades of existence. Is that correct?
That's correct. There are certain regulations that are being proposed by the Federal Trade Commission, specifically the non-compete clause regulation, which it does not appear that the FTC was ever given authority to do that sort of regulation, regardless of whether that is good or bad policy.
Right, so Ms. Ho, I don't want to leave you out of this. The Chevron deference that ultimately creates the ability for, if you challenge in court, the assumption that somehow the Congress has simply had ambiguity. Do you see in the ATF or in the FTC, do you see ambiguity in the original law that would cause decades after one precedent was set to be changed simply by a change in who happens to occupy the chairmanship and, of course, the White House.
Thank you for that question. I wouldn't presume to comment on the details of any specific legislation, but I would go back.
Well, Chevron isn't legislation. Chevron is a Supreme Court decision that essentially says the court is going to assume that these agencies act in good faith and that it's simply ambiguity in the law. Do you believe there's ambiguity in either of these two decisions, or are you unwilling to comment on them?
Oh, I can't. I'm not in a position to comment on either of them, but I do underscore the significant flaw in the Chevron approach, which essentially takes away this body's ability to make law, and also the judiciary's constitutional responsibility to say what that law is.
So in my remaining few seconds, for all of the witnesses, including Ms. Hammond, is it fair to say that instead of working on the REINS Act, perhaps we should be working on explicitly eliminating Chevron and putting the deference back to you must return to Congress if there's ambiguity? Any comments?
The gentleman's time has expired, but I'll allow one witness to respond to that. Mr. Wolfson.
I guess I'll take it. I think that eliminating Chevron deference or curtailing it significantly would be an action that Congress could take, which would have an even bigger effect than something like the REINS Act, because the REINS Act was only prospective, whereas eliminating Chevron deference affects all regulation that are currently on the books.
Thank you, Mr. Chairman. I yield back.
The gentleman yields back. The chair now recognizes the gentleman from Rhode Island, ranking member, Mr. Cicilline, for 5 minutes.
Thank you, Mr. Chairman. I want to quickly dispense with one thing, Mr. Wolfson. You said in your testimony here just now and in your written testimony that agency expertise is really expertise in the regulatory process, not on the complicated trade-offs between competing priorities. You're not suggesting, I hope, that the thousands of scientists who work at the FDA or the thousands of engineers and products experts that work at the Consumer Product Safety Division are only experts in the regulatory process and not the underlying science or engineering that they were trained to do, are you?
Thank you for the question. No, I'm not suggesting that they.
Thank you. So reclaim my. So my point is, regulators have expertise, not just an understanding of the regulatory process, but they're hired in these agencies of the federal government because they bring with them life-saving training and science and expertise that we don't have as members of Congress. And so the notion of all they know about is the regulatory process, which is what you say here, that's exaggerated. It's actually the underlying substance of their expertise that is saving the lives of the American people. So I just wanted to be sure that you weren't making a claim to the contrary. Professor Hammond, what I want to ask you about is, would the response to environmental calamities like the one that was caused by Norfolk Southern train derailment, East Palestine, be better or worse off if the EPA were subjected to the REINS Act that is being offered by my colleagues on the other side of the aisle?
Thank you for that question. Very much worse off. Agencies need those regulations to then carry out their work, whether that's investigatory work or enforcement work. Plus, one of the things I want to emphasize is that regulations protect people in the first place. They help keep disasters like East Palestine from happening. So we can back it up a minute and just think about, let's prevent harms instead of waiting for disasters.
And, would requiring Congress, rather than agencies that are equipped with both expertise and professionals who do this work, a body of, Congress, those of us that are elected members who are not scientists or experts on public health or environmental protection, worker protection, safety provisions, would it endanger the lives of the American people if we were to second-guess agency decision-making that is, in fact, intended to keep Americans safe? And how much longer would it take for these regulations, which, in fact, are saving people's lives, to go into effect, if they would ever go into effect, if the REINS Act became law?
I think the concern is that they would never go into effect, and we'd be left with huge gaps in protection across every field of our economy. And so, although we might envision a system where Congress tried to legislate every regulatory detail, as you mentioned, there's a matter of comparative institutional expertise here. And agencies really have the expertise to bring that kind of scientific informed judgment to those regulatory protections.
And let me just end with a very specific example. During the Trump administration, the Federal Railroad Administration withdrew an Obama-era notice of proposed rulemaking mandating 2 qualified crew members on most freight locomotives. Workers have strongly supported a crew size mandate like this one, as they believe it's integral to rail safety. Although the Biden administration has re-proposed this rule, railroads have staunchly opposed this safeguard. Under the RAINS Act, railroads would have even more leeway to influence rules like this one through lobbying members to use an unconstitutional one-chamber veto of such a rule. And so my question is, would the RAINS Act provide more protection for workers and people who use the rails, and sometimes less protection for hazardous materials that they transport, or less? In other words, would worker safety be impacted in a positive way or a negative way if the RAINS Act were in place?
Certainly in a negative way. We should be listening to those workers.
And with respect to the notion that the regulatory process is difficult to follow and doesn't have the voices of the American people embedded in that process, would you respond to that argument, Professor?
Sure. Under the Administrative Procedure Act, all agencies are required to have a period of notice and comment. Anyone, any person can offer comments, and although there is room to bring even more voices to that process, agencies are required to respond to the significant comments that are raised and incorporate that understanding into their final rules. So there's very much a sense of participation and democratic accountability embedded in the process.
Thank you, Professor. I yield back, Mr. Chairman.
Ranking member yields back, and I now recognize the gentleman from Colorado, Mr. Buck, for 5 minutes.
I thank the chair. Ms. Ho, I want to direct these questions to you and I guess my comments also. We have a situation in Congress where we have a large number of programs that are unauthorized. The programs were originally set up with a sunset provision, typically 5 years. The 5 years has expired, and I want to just, there are actually 1,200 programs that have now expired, and Congress refuses to do its job and review those programs. When Congress pretended that it cared about spending, it set up a 2-step process. And the first step was to authorize a program, and the second step was to appropriate to the authorized program. The rules of Congress for the last 50 years have included a provision that requires Congress not to appropriate to an unauthorized program. What's so interesting about that is Congress waives its own rules for each appropriations bill so that it can bypass the responsibility of actually appropriating only to authorized programs. The purpose of this, obviously, is that Congress, as responsible to the American people, should be reviewing these programs, determining if these programs need to be expanded, contracted, amended in some way so that they are more responsible. My question has to do with the interaction or interplay of the Chevron doctrine with the concept of Congress's responsibility in overseeing these particular programs.
Yes, thank you for that. Thank you for that thoughtful question. And I agree that the scenario that you lay out highlights, I think, one of the critical aspects, and why I think it's so important that we're here today having this discussion. It is as important and salutary for Congress to exert its lawful authority under the system that our founders designed, and that when Congress doesn't, we shouldn't be surprised to see other branches sort of exploiting that lack of action. So I think your question really highlights the important role that Congress has to play in ensuring that our system of separation of powers that the founders bequeathed to us remains vibrant and effective in safeguarding individual rights and liberties. Thank you for that question.
And I have to say, I think that you are far too kind. You understand that you're testifying in Congress, and you are a gentlelady from the great state of Texas, and I respect all those things. But the reality is Congress has failed to do its job. And part of the problem and the reason for these administrative agencies overstepping their bounds, and the one that gets under my skin, and I'm sure my good friend from Wyoming, Ms. Hageman, would agree with me on this, is the WOTUS rule. It comes up every time the Democrats get into the White House, the waters of the U.S., and every time my district actually borders the state of Wyoming, and we share water. And if the Democrats get to regulate ditch water in my district, in every puddle in my district, we're going to have problems. And so the idea that these agencies can expand their authority is really, they are filling a vacuum that Congress has created. And my point, and I'm hoping to get your comment on this, my point is that without Congress's neglect, without Congress's failure to act, we wouldn't be dealing with the REINS Act right now, because we would actually be doing our job every day of overseeing the functions in the executive branch.
Yes, Your Honor, I think the founders well understood and anticipated the very, I think, dysfunction you describe, which is it creates real problems in our system of separation of powers when one branch does not exert its lawful authority, does not do its job. And so for this branch, as you highlight, this branch's role in our constitutional form of government is to make law. And so when Congress does not, when Congress passes, say, vague laws, or when Congress does not act at all, it upsets the system of checks and balances.
I yield back. Thank you.
The gentleman yields back. The chair now recognizes the ranking member of the full committee, Mr. Nadler, for 5 minutes.
Thank you, Mr. Chairman. Mr. Buck's discussion of the fact that Congress can't find the time to reauthorize all the programs leads me to wonder how Congress would ever find the time to go over thousands and thousands of detailed regulations. My understanding is that under the REINS Act, many industries will be expected to self-govern. Professor Hammond, do you think the railroad industry will do this effectively, putting health and safety above profits?
No, there's a long and well-documented history of a concerted effort by the entire industry to resist any safety requirements. The REINS Act only makes it more difficult to actually put those protections into place.
In addition to the dangerous REINS Act, which we've discussed, members of the subcommittee also support the Separation of Powers Restoration Act, which would eliminate Chevron deference. That is, deferring to expert agencies on their interpretation of statute, so long as it's not unreasonable. Professor Hammond, do you think public health and safety would be improved or hindered if agencies lacked this deference and had constantly to go to court over their authorizing statute?
It would be much more difficult to protect the public. And I would like to just point out that I'm hearing the words Chevron deference, but the Chevron doctrine itself has a key component that this discussion so far has overlooked, which is the first step. If the statute is clear, the analysis stops. There is no deference to the agency because the clear language of the statute controls. It's only if there's ambiguity that is a matter of comparative institutional competence, as between the courts and the agencies, that a court should not be substituting its own policy preference for the way the agency exerted its expertise and did so with political accountability. So the Chevron doctrine itself has quite a bit more nuance and does recognize the expertise of agencies, but certainly has guardrails in place for congressional oversight.
Thank you, and I assume that if an agency abused its authority under the Chevron doctrine, that's subject to challenge in court?
Certainly.
Thank you. Supporters of the REINS Act argue that this bill would help tame inflation, despite the fact that the bill could, in fact, result in blocking any major rule contemplated by our expert agencies, even if they're designed to address inflation. Professor Hammond, how do you think the REINS Act, if passed, would affect the economy and inflation?
Well, we know, are we okay there? All right. We know that regulatory protections actually help the economy, and I collected several examples in my written testimony, but just to give you one, EPA's proposed soot rule that was proposed earlier this year would save 270,000 lost workdays. It would also provide $43 billion in net health benefits. That's good for the economy. If the RAINS Act would cut off all of these protections at the knees, we'd see a lot of detrimental economic impact.
Thank you. The National Transportation Safety Board recently launched an investigation of Norfolk Southern following the derailment in East Palestine. The investigation is rare because it will consider Norfolk Southern as a whole rather than the East Palestine incident in particular. Professor Hammond, do you think Norfolk Southern is the only railroad company that needs more regulatory oversight? And do you think that regulatory oversight will be improved under the RAINS Act?
No, and indeed, as I said previously, this is an entire industry-wide effort. And I should mention that self-regulation tends to be a euphemism for putting profits over health, safety, and the environment. We've seen that not just in the railroad industry, but for example, in the extractive energy industries. The RAINS Act, once again, would only undercut the protections that we need.
And you think this applies basically to every area in the economy?
Everyone that I've seen, including even the markets.
Thank you very much. Mr. Chairman, I yield back.
The gentleman yields back. I'm gonna allow one more of our members to take 5 minutes, and then we will vote. So if people want to go ahead and vote right now, we're gonna recess immediately after Mr. Klein. So, and I now recognize Mr. Klein for 5 minutes.
Thank you, Mr. Chairman. I want to thank the witnesses for being here. I'm concerned by something that Professor Hammond said, that there's already a certain degree of accountability in the rulemaking process when, according to a recent study, the Department of Health and Human Services rulemaking practices from 2001 to 2017 revealed that 1,860 FDA final rules, 98% of their total, had been issued illegally, and that other agencies had similar problems in violation of Buckley versus Vallejo, where the Supreme Court held that rulemaking is a significant government power that may be exercised only by officers appointed in accordance with the Constitution's appointment clause. So what we have are unappointed, unelected bureaucrats issuing rules against the law, against the Constitution, and against court rulings. That's why I've introduced legislation called the Ensuring Accountability in Agency Rulemaking Act. It's a bipartisan bill. It says that all rules, except in limited circumstances, have to be signed and issued by an individual appointed by the president and confirmed by the Senate. It's common sense, it's compliant with the Supreme Court precedent, and it would ensure the accountability that the professor claims exists, but really does not at this point. You know, we have a situation where the Biden administration the regulatory burden totals greatly exceed those of its immediate two predecessors. 517 rules have been issued, costing $318 billion in total and requiring more than 218 million hours of paperwork, not by bureaucrats, but by American taxpayers and businesses to comply with these regulations. So, as the AAF put it in their research, the overarching conclusions drawn from this data are hardly surprising. The Obama and Biden administrations imposed regulatory burdens in the hundreds of billions of dollars, while the Trump administration was nominally deregulatory. So in addition to co-sponsoring the RAINS Act, we need to take action legislatively to regain the rulemaking power of the Congress. And I would go to ask Ms. Ho, let's go to another agency. The FTC, under Chair Lena Khan, recently announced a proposed rule that would purport to prohibit non-compete agreements nationally. This comes on the heels of California weakening or eliminating the enforceability of non-compete agreements, which China has capitalized on, and is another method in their arsenal to steal U.S. intellectual property, specifically trade secrets. Do you believe that the proposed rule exceeds the FTC's statutory authority?
Thank you for the question. Without commenting on particular rules, I will underscore that one thing your question highlights is that one way that we know or we can tell or suspect that an agency is exceeding its authority is when it acts in an area that it has not typically acted in before. That's one of the aspects of the major questions doctrine that has been, I think, a topic of interest lately. So where I think one clue perhaps that an agency may be acting outside of its authority is when it is acting in an area that it has not acted in, and also an area where in our system of federalism, states have typically acted.
What's your position on the constitutionality of rules issued that by non-confirmed individuals, essentially violating Buckley v. Vallejo?
I think that's an excellent question. I think I would need to know sort of more facts and circumstances to opine definitively. But I do think, again, your question highlights issues of accountability, accountability to voters.
Mr. Klechner, I believe you spoke to Ms. Khan and the FTC a little bit earlier. Did you? Okay, can you speak to that? All right, Mr. Wolfson.
Yeah, I think that for the FTC to step into an area that they have never previously found authority in the FTC statute, to then say we now have the authority to bar particular behaviors, again, regardless of whether that is a good or bad law. You know, there are a lot of states, red and blue, that are addressing non-compete clauses. So regardless of whether or not that is a good thing, it's kind of like if Health and Human Services said we're going to regulate minimum wage requirements. It's not their bailiwick, and having them do it creates all sorts of problems. And regardless of the level of expertise of the people inside the agencies, it doesn't ever seem to be the case that the people who are at FTC would be the ones in the best position to evaluate those kinds of questions.
All right, thank you. I yield back, Mr. Chairman.
I thank the gentleman for his questions. We're going to take a short recess to vote. This is a special circumstance where there's only one vote, so members can go vote and come back quickly. So the recess I anticipate will probably be about 15 or 20 minutes, and we'll convene as soon as the ranking member and myself return, or his designee, and somebody to ask questions. So encourage the witnesses to take a break, short break. Thank you. The subcommittee now stands in recess. Committee is now back in order, and we'll start where we left off with Mr. Johnson from Georgia. I now recognize him for 5 minutes.
Thank you, Mr. Chairman. Republicans favor low taxes on the wealthy and less government. So low taxes, less government has been their campaign mantra since Ronald Reagan. And to accomplish less government, just about every Republican, including those on this dais, have signed on to the Grover Norquist No New Tax Pledge. And in a 2001 radio interview, Grover Norquist revealed his true intention. He said famously, I'm not in favor of abolishing the government. I just want to shrink it down to the size where we can drown it in the bathtub, end quote. When Republicans are not cutting taxes, they're cutting the ability of federal agencies to protect the public health, safety, and the ability to enjoy freedom and prosperity. The REINS Act, which if passed, would prevent agency rulemaking from protecting the American public from corporate greed that jeopardizes the health and safety of the American people, is a move toward strangling the federal government. In short, what the REINS Act does is puts profit over people. Now, Ms. Ho, you, like the rest of America, observed the congressional dysfunction in its inability to elect a speaker. It took 15 rounds over a 5-day period. You witnessed that spectacle, did you not?
Yes, sir.
And the REINS Act would act as a chokehold on federal agencies' ability to promulgate rules that protect the health, safety, and welfare of the American people, like those in East Palestine, Ohio. Isn't that correct?
Yes, that's my understanding, Your Honor.
Now, there are some people in America who trust the federal government to make sure that our water is safe, our air is safe to breathe. We rely on the regulatory system to improve our lives every day, whether that's by protecting working families from getting ripped off by banks or by ensuring that we have fewer car-related deaths. But in recent years, we've seen the devastation that comes from deregulation. Look no further than the disaster in East Palestine or the water crisis in Flint, Michigan. Congress can pass laws with broad outlines, but we need agencies to translate those laws into actionable policy. Using input from scientists, stakeholders, and the public. These issues are complicated and we need experts working on them, not members of Congress who get caught up in congressional gridlock and can't even elect a speaker. So, Professor Hammond, we're still discovering the fallout from the Norfolk Southern derailment in East Palestine, but we understand that residents are already affected by toxic chemicals that were released into the surrounding air, water, and land. Professor Hammond, will the ability of the federal government to create stronger environmental safeguards be helped or hurt by the passage of the REINS Act?
Thank you for that question. I believe it will be severely hurt. We need those environmental safeguards.
Why is that? Why will the REINS Act hurt?
It's because all of the effort that the agencies have brought to bear, as you mentioned, with scientific and technical expertise on actually evaluating how toxins do impact people's health and the environment, and then actually putting restrictions in place to prevent people's exposure to those. All of that kind of effort, which of course is also informed by a participatory rulemaking process, all of that would be simply extinguished were the REINS Act to be in effect.
So you said in your testimony that we should really be looking at the dysfunction in the courts, which you say is straining separation of powers and disrupting agencies and carrying out the mandates that Congress has given them to protect the people of this country. Can you elaborate on that?
Yes, I was referring to the major questions doctrine, which picked up some traction in the recent West Virginia versus EPA decision. The problem with that doctrine is, as I quoted in there, it's a real power grab by the Supreme Court to be able to substitute its own policy preferences for that of either of the accountable branches.
That's from a right-wing extremist Supreme Court.
Indeed.
I yield back.
Gentleman yields back, and I now recognize Mr. Benz from Oregon for 5 minutes.
Thank you, Mr. Chair, and congratulations on your chairmanship. And thank you for selecting this most interesting topic for today. Back in the small state of Oregon for 8 years, I was on the Water Resource Commission, the last 2 years of which I was chairman, and I had many opportunities to review administrative rules because we wrote the rules for everything having to do with water in that state. I just have to comment on that because of the remarks made earlier about how if you simply go through the rulemaking process, the rule will hew to the statute. Because I guarantee you that's not necessarily what happens. It's a totally political activity, and it's amazing how much damage can be done by the agency as it writes rules. I know because I rewrote them personally myself many times and then was overruled because of the number of votes I didn't have on the commission. So let's just say I don't view the APA as a device through which you can place rules and suddenly have them hew to the statute. It isn't. The question I would have, I want to go back to this Virginia versus EPA discussion. The way I understood it is that case says, quote, a more than merely plausible textual basis for the agency action. So, Ms. Ho, can you tell us, has the problem been solved that we're talking about here today by virtue of that Supreme Court opinion? The problem being overreach by agencies. And I should first, my assumption is that there is overreach. I've observed it myself, but in your opinion, first, is there overreach? And second, has it been resolved by virtue of West Virginia versus EPA?
Thank you for that question. And I think the way that I would put it is I think West Virginia versus EPA is a step toward restoring the proper checks and balances and separation of powers, but certainly isn't and doesn't purport to be a complete solution to the problem that this committee is discussing today.
It also would appear if we wanted less regulations, we would have less laws. We'd have fewer laws to write regulations regarding. There seems to be a massive disconnect between my friends on the other side of the aisle and reality. They seem to be saying that what we want to do away with all statutes and all rules, but that's not the case, is it? All we're trying to do is get it right. And what would your definition of right be here when it comes to what these agencies should be doing?
Well, I think your question highlights, and to get back to bringing up West Virginia versus EPA, I think what the court said there is a very it created a rule that has a long tradition in this body. There are lots of other clear statement rules. It's just saying if we see an agency acting in an area that it hasn't before, in highly politically or socially charged circumstances, we want to make sure that Congress has clearly authorized that agency to act in that way. So we're going to look for a clear statement, just like courts do in sovereign immunity, looks to make sure that Congress has waived sovereign immunity, or in the area of retroactivity, because our tradition is not to have retroactive laws. Courts want to make sure that Congress has done so clearly. So I think West Virginia's rule is just one in a series, in a tradition of rules where the courts have said, look, this is within Congress's authority, and if Congress wants to give that authority to an agency, we want to make very sure that it has done so clearly.
Thank you for that. And Mr. Wolfson, there's been some assertion that this attempt to rein in agencies is unconstitutional, and that somehow Congress, by stepping into this space of administrative rule, is stomping on executive privilege or the executive space. What's your thought?
So my understanding has always been that the legislature's job is to issue the laws, and the regulatory agencies are not really supposed to be writing laws, but they're supposed to be enforcing those laws as Congress wrote them. And so if Congress were to decide that they wanted to pass a law that's super vague, then there become challenges for implementation, and that's where the regulatory state has stepped in. But that's not how the framers designed our Constitution. That shouldn't be the goal. That is kind of where we are, but the fact that we have resulted in a spot where regulations have to be written by regulatory agencies, regardless of how much expertise those people have. They don't have more expertise than the professors at some universities who are talking about these topics, who you could bring in and speak to as members of Congress to write really clear laws that talk about the problems that might be faced.
Thank you. With that, Mr. Chair, yield back.
Gentleman yields back. I now recognize Mr. Ivey from, I'm sorry. Recognize the ranking member for unanimous consent request.
Thank you, Mr. Chairman. I ask unanimous consent to introduce into the record a statement from the United Steelworkers, a written testimony of Elizabeth Skerry from the Regulatory Policy Associate at Public Citizen, a letter from the Center for Progressive Reform, a letter from the Coalition for Sensible Safeguards, an alliance of over 150 labor, scientific, research, good government, faith, community, health, environmental, and public interest groups, and an article from The Hill entitled Buttigieg Calls on Trump to Back Reversing Deregulation in Wake of Train Derailment.
Although these may be unanimous consent requests in need of scrutiny, I hear no objection, and so ordered. Who would the ranking member prefer? Okay.
Thank you, Mr. Chairman. On February 3rd, 50 freight train cars carrying hazardous material derailed, as we know, in a fiery crash on the borders of East Palestine, Ohio, sending toxic chemicals into the surrounding air, soil, and creeks. This incident, in my mind, highlighted the influence of corporate lobbying on railway safety. And I have a bill that you've heard about called the Stop Corporate Capture Act that would lessen corporate influence in the rulemaking process and clear a path for increased public participation. Listening to these comments today, I think the problem is not that regulatory agencies don't have the expertise or should not have a role in regulation. It's that the ledge branch and the rulemaking branch both are too often controlled by special interests, by big corporate lobbying money. And I've got a bill to address that larger issue as well on the legislative side. It's called the Anti-Corruption and Public Integrity Act, and it addresses the legislative side. So Professor Hammond, I just want to dive into this a little bit and see if we can understand exactly what's happened here in the railway industry as an example. Powerful railway lobbyists have spent over $700 million in the past 25 years to cut costs, weaken safety regulations, and strengthen their bottom line. This is at the same time they've been making record profits, by the way. Just as an example, Norfolk Southern paid out $18 billion in stock buybacks and dividends. And at the same time, we've got this weakening of regulation. And I wanted to talk about the Obama-era safety rail regulations as an example that arose from a 2008 Southern California train wreck that killed 25 people and injured 135 others. Can you give us some insight into how frequently lobbyists successfully encourage the administration to scale back or delay implementation?
I don't have an exact number for you, but certainly the evidence is extensive that this is a constant effort by the railroad industry in this particular example, and then of course by other industries with respect to other agency rulemakings.
And talk to me about the PTC, the automated braking technology, and the PTC, which debuted in 1990. In fact, I think it was on the kind of most wanted list of things to do back in 1990 when that technology emerged. But it took 30 years to actually implement. Can you give us some understanding of what happened in that process?
Just briefly, what I understand is that there was an initial support from the railroad industry, but once it became apparent that this would be actually a requirement, there was a decades-long effort to resist it.
So in 2014, Obama also proposed stricter rules for trains that transport petroleum and other hazardous materials. And in 2015, he issued a regulation that required trains carrying highly flammable liquids to be regulated. That met with opposition from whom?
The railroad industry.
The railroad industry. In fact, Norfolk Southern, among others, said that requiring these brakes was, quote, not in the public interest. Do you know, Professor Hammond, what happened next in 2015 when the Republicans came in?
I believe that the rule did not go into effect.
Correct. The Republicans introduced the FAST Act, and it simply proposed a cost-benefit analysis of these electronic braking systems that had been out there for more than 20 years, but had killed a lot of people. But apparently we wanted to do a cost-benefit analysis. And then in 2018, the rule was repealed by the Trump administration. And they issued a rule to remove the advanced braking system. And in fact, in the House, the new GOP chair of the Transportation Committee was the Chamber's top recipient of industries, or is the Chamber's top recipient of industries campaign cash. Norfolk Southern's general counsel, do you know what his background was?
I don't.
Okay, let me tell you. He was the person who pressed for safety waivers, and he is the former executive director of the National Transportation Safety Board. Tell us what the National Transportation Safety Board does.
It indeed regulates the safety.
It regulates the safety of these trains. So it's actually the current body that's investigating the company. So I guess I want to take this in our last minutes to the Stop Corporate Capture Act and ask you, in my bill, we enhance the public's notice and comment influence through the Office of the Public Advocate. How would an increase in public participation improve the rulemaking process?
It would bring more voices that could be counteracting this extensive, very expensive, consistent effort by industry to capture the process.
And bring us the voices of the people on the ground that we are sworn to protect.
Ladies.
Thank you, Mr. Chairman. And also, Mr. Chairman, may I ask unanimous consent to enter into the record a number of items. The first is a letter of support for the Stop Corporate Capture Act. The second is an oil and gas, an article on how oil and gas lobby buries the findings of negative impacts of fossil fuels. The third is a letter from All Aboard Ohio on Norfolk Southern's influence on safety regulations. And the fourth is a study on the presence and influence in lobbying on SEC rulemaking that shows that the influence of lobby groups outweighs public comments.
Without objection.
Thank you, Mr. Chairman. I yield back.
The general yields back. The gentleman from North Carolina is now recognized for 5 minutes.
So, Professor Hammond, I've listened with interest to the number of times that the East Palestine derailment has been invoked. Do I understand that this existing regime of rulemaking under the Administrative Procedure Act through the administration is susceptible to influence from special interests?
Yes, that's why I think that Representative Jayapal's approach is a good one.
So the conclusion that she draws is it would be a bad idea to reinvigorate Congress's participation in the making of the necessary rules because there would be political influence in Congress. But there's political influence in the rulemaking process under the APA, isn't that right?
Would the gentleman yield because you are speaking about me?
No, I won't.
Well, you're implying things that I did not say.
I'm talking about your question. I'm talking about your question, which stands for, I'm not arguing with you, it's my time.
Okay, but please
It's my time.
Please don't
Would you respect the order of the committee, please?
The gentleman from North Carolina is recognized. It's his time.
Mr. Chairman, if
He has not impugned the other member
but I'm
or
just-
her motives.
Can I have time back on my, I've been interrupted about 30 seconds
yeah,
of
the
time
gentleman
by
will get an
disorder from
additional-
the other side of the aisle, Mr. Chairman. Could I have my time back?
Gentleman will
Mr.
receive
Chairman,
an additional 30 seconds.
Procedural
The
question.
committee's not in order, Mr. Chairman.
I raise a point of order, Mr. Chairman. I would raise a point of order. Does a member of the committee have a right to correct?
What rule?
I'm raising a point, I'm asking you to rule on a point of order. Does a member of the committee, or a point of parliamentary inquiry, does a member of the committee have the ability to correct a misstatement of a question that was posed by one member? Because without the ability to correct that, a witness is then going to be invited to respond to something she didn't say, which seems sort of Alice in Wonderland-ish and maybe not a great practice. So is she permitted to seek that be corrected before the witness answers?
The member may ask for the other member to yield, but the member is not required to yield. If a written statement wants to be submitted, we'll accept that.
Okay, thank you.
The gentleman from North Carolina is now recognized again, and he'll have an additional 30 seconds.
Thank you, Mr. Chairman. So I'm not sure how it stands to reason if allegedly the administrative process has been susceptible to political influence, that would be a distinct or different set of circumstances if Congress instead were making the laws. Can you explain why that's one? It would be present in one and not the other, given what you've talked about East Palestine and the federal regulations on transportation?
Sir, I have not said that corporate influence is present in one and not the other, and I very much am of the mind that there can be improvement in both branches. One of the differences in the administrative branch is that at least we have more transparency, which becomes opaque were the REINS Act to go into effect.
Is it possible that the East Palestine derailment occurred because of enforcement, because of administrative incompetence? That is to say that, let's say the administration, let's say the Mayor Pete is more interested in talking about whether highways are racist and diversity, equity, and inclusion than focusing on the nuts and bolts of transportation. So you see things like this crop up. Is that possible?
Sir, I'm not aware of facts that support that assertion.
No, I didn't ask if you were aware of, I asked if it's a possible set of reason contributing. In fact, do you have any evidence that it was caused by the lack of a particular regulation rather than the administrative distraction?
I do understand that one of the possible failures in that wreck, and I believe the investigation is still underway, is equipment that appears to be completely unregulated.
Okay, so it's possible. Either one seems possible to me. I pulled up quickly the Administrative Procedure Act has been in force since 1946. The 5 volumes of regulations on transportation in Part 49 of CFR totals 4,634 pages. How can, if that's the case, I mean, that is the state of affairs. And what I understand is they're arguing that East Palestine is an example of why we need to maintain that. How many pages of regulations would be necessary in the transportation part so that we wouldn't have things like East Palestine?
I can't give you a page number, but from having been involved in writing regulations, it just takes a little bit of work to set forth all of those technical details that are important to clearly understand what is expected and to clearly present the protections that are necessary.
You testified, as I was going back and forth and listening on audio remotely, at some point you testified that if we had fewer regulations, it would do harm to the economy, right? Are you an economist?
I'm not an economist, but I read the cost-benefit analyses that agencies prepare for their OIRA review, and in those, you can see the extraordinary benefits to the economy of many protective regulations.
So you haven't felt it an impediment to your forming that conclusion or that opinion based on reviewing the expertise of others. You haven't found it to be an impediment that you lack a specific expertise in the area, right?
It's written reasonably well so that most educated people can understand.
And all of this expertise that exists in all these magnificent agencies can be drawn upon by Congress, by committees just like this, to be advised upon whether a particular rule ought to be made a law. Isn't that true? In the same way you formed your conclusion from inputs by experts.
I'm not sure I understand the question, sir.
Okay. Do you understand the question, Mr. Wolfson? Do you have a thought about it?
I believe that this body or any other body of Congress would be able to call experts from across industry, from the academy, others who are experts who have worked on these areas for a long time, whether they are in the government or outside of the government, and could gain the expertise in the same way that the regulatory agencies attempt to do through the notice and comment process.
All right, my time's expired, thanks.
The gentleman yields back. The gentleman from California, Mr. Correa, is recognized for 5 minutes.
Thank you, Mr. Chairman. I just wanted noted that I returned to the committee.
It's very much appreciated.
Thank you, sir.
My lobbying was successful.
Yes, it was.
Lou, do you want like a formal welcome from the Democratic side as well?
I got it from them, Mr. Ranking Member. Just want to take my first 30 seconds and yield to my colleague, Ms. Jayapal.
Thank you so much. I am very happy you're back on the committee. I just wanted to correct the record because my colleague across the aisle was saying things I didn't say. What I have said consistently, and the legislation I have introduced consistently, is both to implement reforms so that the legislative process works for the people that we represent and not for big corporate interests, and to propose regulation that would help the regulatory side, or legislation that would help the regulatory side to do the same thing. Thank you, Mr. Correa, for yielding.
Thank you very much. I just wanted to thank the witnesses today for your testimony. It reminds me of a law school constitutional class. Very interesting. But Ms. Ho, I wanted to, if I can, ask you and discuss with you a little bit of the Chevron doctrine, which is essentially the deference doctrine. Did you say something about congressional neglect? Were those some of your words, or was that another witnesses that said something to the effect?
I think one of the points that I made in my opening, Your Honor, is that when this body, when Congress does not act, when it does not exert its role as the maker of laws, it sort of leaves a vacuum where other branches, particularly the executive, can step into that void.
Thank you. And I ask this because you've got what appears to be a conflict challenge here between the executive and our body, rulemaking, and you have the third, which is referee, the third branch of our government, United States Supreme Court, that ruled in the Chevron doctrine. Today we have, as always, the Supreme Court changes, new members, new justices. So is there a possibility that in the future there may be a new decision on the Chevron doctrine that maybe affirm it or maybe not affirm it?
You know, that's a great question. I know just enough about the Supreme Court to know never to try to predict what it will do. I do think it's interesting that in a decision recently by the court, Justice Kagan authored a decision called Kaiser, which trimmed back our deference, which involves agencies, courts dealing with agencies' interpretations of their own regulations. And the Chief Justice wrote separately in that case to say that because the court actually did not overrule our in that case, that decision should not be understood as closing down requests for the court to revisit the Chevron decision sometime in the future.
And I ask that because I have the highest respect for our Supreme Court, our third branch of government, and their decision-making and thinking about, we're essentially talking about the REINS Act, trying to correct something that some of us view as a flawed decision. And that, given the case, I think it's important to see where the Supreme Court may be going in the future. Thank you. And Professor Hammond, just wanted to ask you, do regulations supersede congressional authority?
No, they don't.
And if they do?
Then a court can strike it down, and of course Congress can also correct the agency.
What is the Administrative Procedure Act?
It is the fundamental procedural statute that Congress passed, indeed, in 1946. to ensure that agencies follow various procedural rules to ensure participatory and reasoned decision-making.
Participatory meaning transparency.
That's right.
Input by the public, those that may be interested or not in the decision-making. All this, though, always being consistent with congressional authority, congressional, essentially, view. Go ahead.
Yes, that's right. The Administrative Procedure Act also has provisions for judicial review, and it provides that one of the reasons a court can strike down what an agency has done is failure to attend to the statutory mandate.
Thank you very much. Mr. Chair, I yield.
The gentleman yields back. Mr. Fitzgerald from Wisconsin is now recognized for 5 minutes.
Mr. Chair, I'm going to yield some time to Mr. Bishop.
I thank the gentleman, and I'm sorry, Mr. Fitzgerald, could you yield to me at the end of your time?
Very good, very good. Both this Congress and last Congress, I introduced Separation of Powers Restoration Act, or SOPRA, which would displace precedent established in Chevron, the case you're talking about, NRDC. And as you know, in this case, Supreme Court required judicial deference to government agency interpretations of ambiguous statutes. This bill, I believe, would tip the scale back in favor of listening to what Congress has to say in its statutes rather than how an agency interprets them. Ms. Ho, what's your interpretation of the Chevron precedent? And do you believe it's worthwhile for Congress to try and reclaim some of its power that for years has gone to the executive branch through agency interpretation of statutes and regulations?
Thank you. Let me begin with the last part of your question. I certainly agree that it's critical in our system of checks and balances and separation of powers for Congress, for this body, to exert its lawful authority as the maker of laws in our land. As to Chevron, and somewhat relatedly, I think, one thing that is interesting about that case is even though as it has come to be sort of a decision involving administrative agencies, that decision nowhere cites the Administrative Procedure Act. So I think a decision that sort of sets forth this notion of deference is entirely outside the bounds of what this court set out, which some have referred to as the Constitution of the administrative state, the Administrative Procedure Act. That decision nowhere cites or even engages with what this court set into law in the Administrative Procedure Act.
Very good, thank you. Mr. Chair, I also wanted to just spotlight an example of the politicization that's occurring at the Biden administration's FTC right now that you're well aware of. Last week it was reported that Fight Corporate Monopolies, a 501c4 arm of the American Economic Liberties Project, intended to air attack ads on primetime TV against myself and you, the chairman of this subcommittee, and other colleagues. In fact, this organization hired a mobile billboard truck to drive through my district due to my opposition to the FTC non-compete rule that we've been discussing today. Certain groups coming after members of Congress with misleading information isn't particularly new, but I was disturbed to learn that Ms. Sarah Miller, the executive director of the very group I just mentioned, as of Monday, is now working for Chairwoman Khan as a senior advisor and is likely to work on the very issue she attacked us on just last week. So, I mean, you couldn't ask for a more current and better example of what's going on at the Biden administration's FTC. And with that, I will yield the balance of my time to Mr. Bishop.
I thank the gentleman for yielding, and it does seem to me, pursuant to or apropos of the conversation that happened in part on my time, if that process, I mean, the notion here is, well, we have to rely on the agencies to make rules because the agencies is where expertise is brought to bear, and that this will be somehow less susceptible to politics. And what I thank the gentlelady from Washington for raising it. The administrative process appears in the creation of rules appears to be susceptible to influence from corporate lobbyists. Some say a few people have seen a corporate lobbyist or two around Capitol Hill. And so if you're talking about one or the other, then it seems to me a false choice that you're going to get rid of politics by leaving it in the administration. In fact, what you're going to do is you're going to effectively put lawmaking into the hands of executive officials higher up. Let me ask you, Mr. Klechner, some years ago there was the Operation Choke Point. Are you familiar with that situation?
I am, sir, yes.
And so several agencies, the FDIC, Office of the Comptroller of the Currency, the DOJ, came together at the same time to have a new regulation that would encourage banks to not do business with businesses that were in the manufacturing arms or something like that. Isn't that correct?
That's correct.
There's no reason to believe that was a product of sudden expertise, is it? That was a political thing, yeah?
Completely political and done secretly for a couple years till it even came out that it was official.
So if you wanted to place lawmaking in the hands of people who don't have broad popular support, would there be any better way to do it than do it through this administrative law system?
You need it to be done by people who are accountable to the American public.
Professor Hammond, do you believe in the principle that government derives its legitimacy from the consent of the governed?
Yes.
The witness may answer, and the gentleman's time has expired. Does the gentleman yield back? The gentleman yields back, and I'll recognize Ms. Scanlon from Pennsylvania for 5 minutes.
Thank you, Mr. Chairman. So as I understand it, and I'm, regulatory, lawmaking, whatever, it's not something we talk about usually over the dinner table, not something I get a lot of questions about in my town halls. But as I understand it, this hearing's been called to address concerns about the proper balance between Congress and the federal agencies on how we create rules and regulations with enough detail to implement and oversee the laws that Congress passes for the benefit, presumably, of the American people. And those rules have a huge impact on public health and safety. When we get in a plane, it helps ensure the plane's not going to crash, that when we eat food, it's safe, or so is medications that we take. Businesses can't scam us out of our hard-earned dollars, and employers have to provide safe workspaces. So these are all the things that these regulations do. And as I understand it, we have about 4,000 to 6,000 of these rules published every year. But to hear what we're hearing in the rhetoric today, these federal agencies are running roughshod over Congress, and there's nothing Congress can do about it. But that's not how it works. Basically, an agency convenes, as we've heard, experts and seeks public input and publishes rules, and there's a whole process where people can have input. We can look at this, and before these regulations take effect, Congress has to be notified. And with respect to major regulations, which is what this RAIN Act seeks to address, and there's about 60 to 80 of them a year, it ebbs and flows a little bit, those regulations can't take effect for an additional 60 days after Congress is notified. So Congress has this window in which to say, nope, don't like that law, nope, we want to change it in some way, and in fact is trying to do that as we speak. So if Congress isn't using that authority, it's not the federal agency's fault. It's, I think, as people have variously described it today, it's a matter of congressional neglect, that there's a vacuum, that there's a lack of bandwidth and staffing. So it appears to me a better use of resources, that if we want to adjust some of the terms of the act or provide more resources to Congress so Congress can better exercise its oversight capability, that's where we should be pushing, instead of trying to add additional workload to Congress, requiring passage of more bills through the Senate. I mean, I think we do have bipartisan agreement that the Senate doesn't work fast enough as it is now. And to require it to pass every major regulation that the federal government needs to put into effect for the health and safety of Americans would be a huge disservice. So just turning to the practical impact of what we're talking about here. It's my understanding that the RAINS Act could undo multiple major rules, including many that keep our kids safe. Professor Hammond, could you give us a couple examples of regs that protect our children, whether from consumer products or food or medication?
Yes, indeed. The one that I mentioned earlier with respect to soot. Kids, of course, are more vulnerable to air pollution, and that's a proposed regulation, particularly for people, kids who have asthma as well as others. So I don't have a specific example in mind from some of the other agencies, but that's one that I think is a great one.
Well, and that particularly resonates with me because the Philadelphia area has one of the highest rates of childhood asthma in the country. 1 in 4 kids in our region has environmentally induced childhood asthma. It's a huge, huge problem. And so obviously I, for one, would like our best experts looking at these things and trying to figure out how we can best ensure the safety of our children. And with that, I would ask unanimous consent to introduce a letter from the American Lung Association, Allergy and Asthma Network, National Association of Pediatric Nurse Practitioners, and a whole range of folks expressing their strong opposition to the RAINS Act because of its harmful impact on our communities. And with that, I would yield back after unanimous consent.
Without objection. And
Thank you.
the gentlelady yields back. The gentlelady from Wyoming, Ms. Hageman, is now recognized for 5 minutes.
Thank you, Chairman Massey. Professor Hammond, do you know what the cost of the federal regulatory burden is in this country on a yearly basis?
I don't have the number at the
Well,
tip of my tongue.
would it surprise you to know that it's over $2.1 trillion, and that's just the federal regulations?
I wouldn't be surprised to compare that to the benefits and find that it's
So
lower.
I want to go ahead and address some of the reasons as to why I'm here and why I actually ran for Congress. I've been a water, natural resource, and constitutional attorney for over 30 years. And one of the things that I've had to deal with on behalf of my clients is the overwhelming regulatory burden that they must navigate pretty much every single day of their lives. The Administrative Procedure Act provides only minimal protection against agency overreach, but it at least does require some form of a process which allows some participation by the American public. But I recently had a case involving the USDA, the United States Department of Agriculture. And a couple of years ago, they posted on their website a 2-page guidance document. And this guidance document required all of our livestock producers to start using RFID ear tags and to register their ranches with the federal government. According to the USDA, this would have had a $2 billion cost on the livestock industry. It didn't go through a rulemaking process. It didn't go through notice and comment. They didn't invite the ranchers in to discuss whether it was even feasible in a 100,000-acre ranch out in Wyoming as to whether they would be able to use this kind of technology. It was just simply issued from on high. And I can assure you that that happens every day from these agencies. Guidance documents, answers to frequently asked questions, they have all different kinds of names that they use, but the reality is that they're used to circumvent the rulemaking process. Are you aware of that, Professor Hammond?
I'm familiar with guidance documents.
Okay, so the Trump administration actually worked to address the issue of the agency abuse of guidance documents through executive orders 13891 and 13892. And notably, by the end of the Trump administration, which all it did was require these agencies to post on their websites what guidance documents they had issued. The bump stock document, I believe, is banning the ATF's effort to ban bump stocks, I believe, was through a guidance document, since the ATF did not have the authority to issue that as a regulation. But by the end of the Trump administration, several agencies had actually established an online portal, and there were over 70,000 guidance documents from just a few of those agencies. So, Mr. Wolfson, can you please explain for us how guidance documents obfuscate these already minimal protections under the APA and further throw into peril the notion of self-governance and government accountability?
Thank you, Congresswoman. And yes, the guidance document problem exists in part because the agencies know that that's a loophole. And so you've got regulators who want to regulate. They may not want, their expertise really is in understanding the process of how to get regulations done. And they know that they don't have to go through the Administrative Procedures Act if they have a guidance document. the kind of the quintessential example people point to is the Department of Education's Dear Colleagues letter toward the end of the Obama administration. And all of these things end up basically hinting that there may be regulatory enforcement by the agency if certain practices are not undertaken. And this changes people's behavior, even if there's no legislative authority behind that guidance document.
So what was interesting is Executive Order 13891 and 13892 were just really transparency requirements. Isn't that correct?
That's absolutely right. And when I was at the Labor Department, we had to review over 13,000 guidance documents, some of which only existed in paper form at the library at the Department of Labor.
Okay, and are either of those executive orders still in place?
Unfortunately, no.
And why is that?
I don't know the inside workings, but it's unfortunate that I believe that, for example, the EPA no longer even has their guidance portal. So people who want to find the guidance documents have to go back to the old method of kind of searching through the entire EPA's website in order to find those.
Well, isn't it correct, Mr. Wolfson, that one of the very first things that President Biden did when he took office was he nullified those two executive orders?
That is correct. So
this administration intentionally made it difficult for the American citizens to learn about the guidance documents that are in force and effect in these agencies, and intentionally is hiding the information that is so important for the regulated community. Isn't that fair?
It certainly would be an assumption one could make from what has gone on.
All right, thank you. I yield back.
The gentleman yields back. The gentleman from Texas, Mr. Moran, is recognized for 5 minutes.
Thank you, Mr. Chairman. I'm convinced that the preservation of liberty does not just happen through the substantive decisions that we make here in Congress. Rather, and just as importantly, the preservation is a result of structural safeguards that our Constitution put in place almost 250 years ago. Important structural principles embedded in our Constitution and the history of this nation, like separation of powers, checks and balances, federalism, they're critical to preserving life, liberty, and the pursuit of happiness is something I talk about often when I talk to my constituents to say we cannot seek an end and in the meantime trample over the correct means. We must preserve those structural safeguards, and that's what we're talking about here today is separation of powers. Unfortunately, over the years, both Democrats and Republicans have eroded these structural protections in pursuit of some substantive end that fits with our or their political agenda, and it's a problem with both parties. And it's the American people who suffer as a result of that. Professor Hammond, I want to start with you. You mentioned that there is room to bring more voice to the rulemaking process. I think I wrote that quote down correctly. If agencies, though, during that rulemaking process run into overwhelming opposition to a rule, a proposed rule, are they bound to reform the rule to accommodate those comments, or can they simply proceed forward in the manner that they would like?
The requirement is that they respond to significant comments raised, and very frequently agencies do adjust their final rules as compared to their proposed rules based on the comments that they receive.
And I know that's the answer, but the true answer to my question is they don't have to. They can simply ignore the comments from the public. They can simply move forward with the rule that they would like to put in place, and they do not have to respond to react. They're not accountable to the people of this nation. We, the elected officials, are accountable to the people in this nation. We are entrusted with decision-making when it comes to lawmaking. They are not, and that is the point that I want to make with that question. To overturn a rule that was been put in place, let's talk about that for a moment as well, because under the Congressional Review Act, which one of my colleagues mentioned is the method by which we can do that, it's not just the House that can do that on its own, but instead we have to pass a resolution to disapprove the rule, then we have to send it to the Senate, they have to disapprove the rule, and then it goes to the President, and he must sign that joint resolution from Congress to undo that rule. Isn't that correct, Professor Hammond?
I believe the rule does not go into effect without that, so it indeed undoes the rule.
But without that process happening, effectively a veto that must require disapproval by the House and the Senate and then to the President, who oversees and ostensibly is directing the very rulemaking that we're trying to overrule, we can't prevent it from going into place. Isn't that true?
Are you speaking about the REINS Act as proposed, or are you speaking about the Congressional Review Act?
Congressional Review Act.
Yes, it is in place.
Yeah, and I'm saying this, the point I'm trying to make here is effectively we can't undo what an administrative agency is actually going to put in place unless we get through that whole process. And it's nearly impossible because it turns on its head the lawmaking responsibility of Congress, because instead of us having some almost impossible veto power over an agency, we should be, in fact, be in the primary place to put those rules in place to begin with, or to enact those laws. I want to go back to Ms. Ho. I have just a minute. If we work to eliminate the Chevron standard, I want you to speak more to what you believe should be the replacement standard there.
Certainly, I think the replacement is the foundational principle of the judiciary, and that is, it is the province of the judiciary to say what the law is. So I think that would be a return to the bedrock principle and the proper putting the judiciary as well in its proper sphere of operation in our system of separation of power and checks and balances.
Thank you. It seems so simple, doesn't it? Separation of powers. It's not a complex concept, but over time, again, I think both parties have eroded that. And unfortunately, we're having to deal with that today. Mr. Wolfson, non-compete clauses, just with 15 seconds, are an integral part, in my opinion, to protecting confidential and proprietary information for businesses, generating innovation and investment. Do you agree with that?
I think there are places where non-compete clauses make a lot of sense. There's probably other places that they don't make a lot of sense. For example, there's some examples of, for example, fast food restaurants that may require line workers to have a non-compete. I think that there's a great policy discussion that we should be having about this, but the place to have those kinds of policy discussions is in the halls of Congress, or more appropriately, actually, is in the halls of the individual legislatures of the states, who can evaluate in their particular states, are non-compete clauses being used appropriately or not.
I completely agree. I yield back. Thank you.
The gentleman yields back, and I now recognize myself for 5 minutes. We've had a great discussion today about the structure and nature of our republic, and actually how far we've wandered afield from our original founders' intent of having separation of powers. So much power has been concentrated within the executive that actually the lobbyists have gone there now. I don't see many lobbyists here today very concerned about what we're doing. They're all over at the executive branch and at the administration. And in fact, under the Obama White House, Google was co-resident. They hired high-level Google people to run the patent board, to sit inside the White House. So I reject this notion that somehow the executive branch is immune to lobbying. But we've been at a very high level for the most part today, and that's what's made this a really good hearing. We've talked about the structure and nature of government. But Mr. Klechner, I want you to boil this down to the specific example of a recent rule on the pistol brace and what that means, how many people it's going to affect. Are these civil infractions or criminal infractions? Can you tell us about the pistol brace rule, when it goes into effect, and what the consequences are of letting an agency write law?
Thank you, Mr. Chairman. I've heard plenty today about profits over people, and I think we're putting regulations over people. I don't think we're keeping people safe with more regulations. In fact, I think regulations and rules like the pistol brace one are actually making it more dangerous. On one hand, I love the maxim that every bit of gun control is a claim that gun control doesn't work because they want more gun laws. On the other hand, I see all these regulations are making felons out of otherwise law-abiding citizens. So you asked how many. The Congressional Research Service estimates between 10 and 40 million of these are out there. Most of these Americans do not know that this rule is happening, and even the Americans that do know the rule is happening cannot interpret it because the ATF is using vague, ambiguous language with weights similar to this, with a surface area suitable for that. These citizens cannot make these determinations on their own, and we're talking about a piece of plastic that was previously approved by the ATF that people bought, maybe even unknowingly. It might have come on the firearm already, and they're going to be made into felons. This is 18 U.S.C. law that ATF is trying to redefine and trying to rewrite. And serious crimes, confusing regulations, going back and forth, I don't see how that's helping anybody.
And when does this take effect? When was it announced? When does it take effect? Is the government undergoing an ad campaign on TV right now telling millions of people they're going to become felons in a few weeks?
No, sir. It was technically published in the Federal Register, but they had 90
I hit
days.
refresh on that page every day.
Exactly right. This has changed. They approved these. Another thing we have with the guidance letters is they've been giving separate guidance to each manufacturer. They're not even giving consistent guidance to the industry on what they're allowed to do, so it's conflicting information. That was 2012. A few years later, you couldn't shoulder them. A couple years later, you could. It changes so much, I don't know how someone's going to be able to keep up with what's going on.
But the people who are going to become felons by virtue of an agency making law because there's a different president who hates guns, weren't they assuming, and weren't the manufacturers assuming? Why did they assume it was legal to do what they were doing until this rule went into effect?
They were specifically told by the ATF that it was legal and that they could proceed. And matter of fact, most of these manufacturers have their version of the letter from the ATF on their website that said, these are legal. See, the ATF said it. Some of them even include a copy in the product in the boxes. So all these Americans relied upon the ATF telling them it was good to go, and now they may not even know that it's not. And they're risking being a felon, which, as you know, takes away their right to have any firearm once they're a felon.
It seems like our founders were really wise to put the legislative function in this chamber and in the Senate because we're up for re-election so frequently. But also, I have constituents. We haven't said today, nobody said today that there should be no regulations. My constituents say, just don't change them on me. Let me know what the rules are. Our founders said, the way they set it up required 4 concurrent majorities for a law to change. Think about how intelligent that is. The House had to agree, a House majority, a Senate majority had to agree, and a majority of the Electoral College had to agree in order for a president to sign that bill, and then it had to pass the Supreme Court. How many majorities are required to approve of a bureaucrat changing a law or a rule? As Mr. Moran pointed out, they're not subject to anybody's approval, any voter's approval. Now, you might say the Supreme Court. Okay, the Supreme Court has to approve the regulation, but as Ms. Ho and Mr. Wolfson has pointed out, with Chevron deference, even that majority doesn't have to agree because we'll just defer to the regulators on this. So I think we need to get back to our founders' intent and put the lawmaking authority back in this body. With that, seeing no other members, that concludes today's hearing. We thank the witnesses for appearing before the committee today. We know this takes a lot of time to fly here, to prepare for this, and to put yourself through this. So we appreciate all of you very much for being here and helping us come to an answer, because the answer should come from Congress. It should, on who makes the laws, and I hope we all agree we should be making the law. Without objection, all members will have 5 legislative days to submit additional questions for the witnesses or additional materials for the record, so you could end up with homework as well. And without objection, the hearing is adjourned.
Could you just defend